I was staring at the citation, taped to my front door, when I realized the HOA had finally lost their collective minds. According to the bright yellow paper fluttering in the bitter February wind, my snow fence was an unauthorized structure that violated 17 different covenants, codes, and restrictions. 17. They had actually sat down and counted out 17 reasons why the temporary orange plastic fence protecting my driveway from snowdrifts was apparently destroying property values in our subdivision. My name is William Zimmerman, and I had lived in the Meadowbrook Estates subdivision outside of Rochester, Minnesota, for 8 years without major incident. Sure, there had been the occasional nastogram about leaving my trash cans visible for more than 12 hours after pickup, or that time they complained my mailbox post needed repainting, but nothing like this. Nothing that actually affected my ability to use my property safely during the brutal Minnesota winters we endured every year. The snow fence in question was a standard 4-foot-high orange safety fence, the kind you see at construction sites and ski resorts. I had installed it along the western edge of my driveway in late November, right before the first major snowfall. Anyone who has lived in Minnesota knows that prevailing winds during winter storms blow from the northwest, and my driveway happened to be positioned perfectly to catch massive snowdrifts that would sometimes pile 6 feet high, making it impossible to get my car out without hours of backbreaking shoveling. The snow fence, positioned about 15 feet from the driveway, created a windbreak that caused the snow to deposit before reaching the pavement. It was practical, temporary, and had saved me countless hours of labor over the past 3 months. I pulled the citation off my door and went inside, my boots tracking slush across the entryway. My golden retriever, Buster, greeted me with his usual enthusiasm, and I scratched his ears absently while reading through the document more carefully. The citation was signed by Patricia Hendricks, the president of the Meadowbrook Estates HOA, and it gave me 72 hours to remove the snow fence or face fines of $100 per day. Below her signature was a paragraph in bold letters stating that snow fences were explicitly prohibited under Section 8.4.2 of the amended CC and Articles, which had been updated and filed with the county in October. I had never received any notice about amended CC and Articles. I pulled out my laptop and logged into the HOA's resident portal, searching through the documents section. Sure enough, there was a PDF dated October 15th titled Amended Covenants, Conditions, and Restrictions. I downloaded it and started reading, feeling my blood pressure rise with each page. The document was 47 pages long, written in the kind of dense legal language that made my eyes cross. Buried on page 32 was Section 8.4.2, which stated that temporary fencing of any kind, including but not limited to snow fencing, construction barriers, or decorative borders, were prohibited without written approval from the Architectural Review Committee. The thing was, I had never been notified about these amendments. According to Minnesota law, HOAs were required to provide reasonable notice to homeowners before making changes to governing documents. I checked my email archives, my physical mail records, everything. Nothing. The first I had heard about this was the citation on my door. I called my neighbor, Tom Sheffield, who lived 3 doors down and served on the HOA board as treasurer. Tom was generally a reasonable guy, and we had helped each other with various projects over the years. He answered on the 3rd ring, sounding harried. "William, hey, I was actually going to call you," he said. "I assume you got the citation about your snow fence." "Yeah, and Tom, I have to tell you, this is ridiculous. That fence is the only thing keeping my driveway usable during storms. And I never got any notice about these amended rules. There was a long pause. Look, between you and me, I voted against this particular amendment. Patricia has been on a warpath about what she calls aesthetic violations ever since she became president last spring. She thinks snow fences make the neighborhood look like a construction zone. I tried to explain the practical necessity, especially for properties on the western exposure like yours, but she wouldn't listen. She got Sandra Murphy and Jeff Coleman to vote with her, and that was that. But the notice, Tom, I never received anything about the amendments. Another pause, longer this time. That is a problem. Patricia said she sent emails to everyone, but honestly, I am not sure she actually did. She has been pretty disorganized with record keeping. You might have grounds to challenge this, but you would need to go through the formal appeals process. What does that involve? You would need to submit a written appeal within 5 business days, then appear before the board at the next monthly meeting. That is not until March 15th, though, and the deadline to remove your fence is in 3 days. If you do not remove it, the fines start accumulating, and they will continue even during the appeals process. I thanked Tom and hung up, feeling frustrated. This was clearly a setup. They impose a rule without proper notice, give me 72 hours to comply, but the appeals process takes weeks. Even if I won the appeal, I would have already paid hundreds or thousands in fines, or been forced to remove the fence and deal with impassable snowdrifts for the rest of winter. I decided to call a lawyer. I had used an attorney named Rebecca Strauss a few years back for some contract review work, and she had been sharp and efficient. Her office was in downtown Rochester, and when I explained the situation, she asked me to send over all the documentation and said she would review it that evening. Rebecca called me back at 9 p.m., just as I was finishing dinner. William, this is pretty egregious. Under Minnesota Statute 515B.3103, HOAs are required to provide notice to homeowners before amending the declaration. The statute specifies that notice must be sent by first-class mail or personal delivery. An email might qualify as electronic delivery, but only if the homeowner has explicitly consented to receive official notices electronically. Did you ever sign anything agreeing to electronic delivery? No, never. Then they violated the statute. Moreover, the citation itself is problematic. It references 17 violations, but most of those sections do not actually apply to a temporary snow fence. It looks like they were just throwing everything at the wall to make it seem more serious. Section 8.4.2 is really the only relevant provision, and if that provision was not properly enacted, it is not enforceable. So what do I do? The deadline is in 3 days. Do not remove the fence. I will draft a response letter explaining that you are contesting the citation based on lack of proper notice. We will also file a formal appeal with the board. In the meantime, document everything. Take photos of your fence, your driveway, the snowdrifts on properties without fencing. Keep records of all communications. If they escalate this, we may need to file suit, but I am hoping we can resolve it at the board level. The next morning, Rebecca sent over her letter, and I delivered it personally to Patricia Hendricks. Patricia lived in a pristine colonial-style house at the entrance of the subdivision, with a perfectly manicured lawn that somehow stayed green even under the snow. She answered the door in yoga pants and a fleece pullover, her highlighted blonde hair pulled back in a ponytail. She was probably in her early 50s with the kind of tanned, taut face that suggested regular visits to both the gym and the dermatologist. "William, I assume you are here about the citation," she said, not inviting me in. "I am. I am formally contesting it. You never provided proper notice about the amended CC and Articus, and I do not believe the citation is valid. I handed her the envelope containing Rebecca's letter. She took it without opening it, her lips pressed into a thin line. The CC and Articus were posted on the resident portal. All homeowners have access. Failure to check the portal does not constitute lack of notice. Minnesota law requires notice by mail or personal delivery unless a homeowner has explicitly agreed to electronic delivery. I never agreed to that. Your email list alone does not satisfy the statutory requirement. Her eyes narrowed. You know, William, this attitude is exactly why we have problems in this neighborhood. Rules exist for a reason. Your fence is an eyesore and it sets a bad precedent. If we let you have a snow fence, then everyone will want one, and before you know it, Meadowbrook Estates looks like a trailer park. I felt anger rising in my chest, but kept my voice level. Patricia, that fence is the difference between being able to use my driveway or not. We have had 3 major storms in the past month. Without the fence, I would be shoveling 6-foot drifts every few days. It is a practical necessity, not a decoration. Then perhaps you should have considered the practicalities before buying a house with western exposure. That is not the HOA's problem. The citation stands, and if the fence is not removed by the deadline, fines will begin accruing at $100 per day. Good day, William. She closed the door in my face. I walked back to my truck, shaking with frustration. This was not about property values or aesthetics. This was about control. Patricia Hendricks had decided she did not like my snow fence, and she was going to use whatever power she had to force me to remove it. Legal niceties be damned. The 72-hour deadline passed. I kept the fence up. True to her word, Patricia sent another notice stating that fines were now accruing at $100 per day, and that if I did not comply within 30 days, the HOA would take legal action to enforce the citation and place a lien on my property. Rebecca filed my formal appeal, and we waited for the March 15th board meeting. In the meantime, winter continued its assault on Minnesota. We got another massive storm on February 20th, with over 14 inches of snow and sustained winds gusting to 40 miles per hour. My snow fence performed exactly as designed, creating a barrier that deposited most of the snow in the field beyond my property line. My neighbor to the south, who did not have a snow fence, spent an entire Saturday with a snowblower trying to clear a drift that had completely buried his driveway. I took extensive photos and videos, documenting both the effectiveness of my fence and the problems faced by properties without wind breaks. Rebecca said this evidence would be crucial if we ended up in court. The March 15th board meeting was held in the community center, a small building near the subdivision's playground and pool area. I arrived at 7 p.m. with Rebecca, carrying a folder full of documentation. The room was set up with a table at the front for the 5 board members and rows of folding chairs for residents. About 20 people were in attendance, more than usual. Word had apparently gotten around about the snow fence controversy. Patricia sat in the center seat, flanked by Sandra Murphy and Jeff Coleman on one side, Tom Sheffield and another board member named Karen Wolf on the other. Karen was a retired schoolteacher who generally kept a low profile, and I was not sure which way she would vote on my appeal. Patricia called the meeting to order and worked through routine business, approval of last month's minutes, a financial report from Tom, discussion of plans for spring landscaping. Finally, she reached my agenda item. Item 7. Appeal of Citation 2024-118, William Zimmerman, Unauthorized Snow Fence. Mr. Zimmerman, you have 10 minutes to present your case. I stood up, walking to the front of the room. Rebecca stayed seated, but I could feel her presence, a calming reminder that I had professional support. I took a breath and began. Thank you for the opportunity to address the board. As you all know, I installed a temporary snow fence along my property in November to prevent snowdrifts from blocking my driveway. This type of fence is standard practice in rural Minnesota and is widely used to manage snow accumulation. It is temporary, it is safe, and it is effective. I pulled out a photo showing my driveway after the February storm, clear and usable, and contrasted it with a photo of my neighbor's buried driveway. Without this fence, I would be unable to access my property during major snow events. This is not a cosmetic issue. It is a functional necessity. Sandra Murphy interrupted. But Mr. Zimmerman, the CC and Articus clearly prohibit temporary fencing. You are not exempt from the rules just because you find them inconvenient. I am not asking for an exemption, I replied. I am pointing out that the amended CC and Articus were never properly noticed to homeowners. Under Minnesota law, HOAs must provide notice by mail or personal delivery before amending governing documents. I never received such notice. The first I learned about Section 8.4.2 was when the citation appeared on my door. Patricia leaned forward. The amended CC and Articus were posted on the resident portal on October 15th. All homeowners received an email notification. Can you provide proof of that email? Rebecca spoke up from her seat, her voice cutting through the room. Patricia looked flustered. I sent it to the distribution list. If Mr. Zimmerman did not receive it, that is a problem with his email provider, not with our notice procedure. Under Minnesota Statute 515B.3103, electronic delivery is only valid if the homeowner has explicitly consented to receive official HOA notices electronically, Rebecca continued. Can you provide documentation showing that Mr. Zimmerman or any homeowner signed such consent? The room went silent. Patricia looked at the HOA's attorney, a thin man in a gray suit sitting in the front row. He stood up slowly, introducing himself as David Carlson from the law firm of Carlson and Associates. The HOA takes the position that posting to the resident portal and sending an email notification satisfies the notice requirement. The portal terms of service, which all homeowners agree to when creating an account, include consent to electronic delivery. Rebecca stood up now too. That is a novel interpretation, Mr. Carlson, but it is not supported by the statute or case law. A click-through agreement on a web portal does not constitute the kind of explicit, informed consent required for official HOA notices. If the board wants to test that theory in court, we are prepared to do so. The tension in the room was palpable. Other homeowners were whispering among themselves. Tom Sheffield cleared his throat. Patricia, maybe we should table this discussion and consult with David about the notice requirements. If there is a legitimate legal issue, we need to address it properly. Patricia's face had gone red. We are not tabling anything. The rules are clear. Mr. Zimmerman's fence is in violation and the citation stands. She looked at the other board members. I call for a vote on the appeal, all in favor of upholding the citation. Patricia, Sandra, and Jeff raised their hands. All opposed. Tom raised his hand, followed after a moment by Karen. The vote is 3-2. The citation is upheld and fines will continue to accumulate. Next item on the agenda. I sat down, feeling defeated despite Rebecca's reassuring hand on my shoulder. The meeting continued for another 30 minutes, but I barely heard any of it. As soon as Patricia adjourned, Rebecca and I left, walking out into the cold March night. That went about as expected, Rebecca said. "Patricia is dug in and she has enough votes to push this through." The good news is that we now have a clear record of the board's decision, which we can challenge in court. The bad news is that it is going to cost you time and money. How much are we talking about? If we file suit in district court, my fees will probably run between $5,000 and $10,000, depending on how long it takes and whether they fight us. There will also be court costs. But William, I think we have a strong case. The notice issue alone should be enough to invalidate the amended CC and Articus, and even if a court finds the amendments valid, I think we can argue that a snow fence is a reasonable accommodation for your property's conditions. What about the fines that are piling up? Once we file suit, you can ask the court for a stay of enforcement pending the outcome. That would stop the fines from continuing. You would still owe whatever has already accrued, but we can also ask the court to void those if we prevail. I did the math in my head. It had been 23 days since the original deadline, so I was already at $2,300 in fines. If this dragged on for months, it could easily reach $10,000 or more. Combined with legal fees, I was looking at a significant financial hit, all over a simple snow fence. But it was not really about the fence, it was about the principle. Patricia Hendricks and her cronies had overstepped their authority, and if I did not push back, they would continue to bully other homeowners whenever they felt like it. "File the lawsuit," I told Rebecca. "Let us do this right." Rebecca filed the complaint in Olmsted County District Court on March 22nd. The lawsuit named the Meadowbrook Estates HOA as the defendant and alleged that the HOA had violated Minnesota Statute 515B.3103 by failing to provide proper notice of the amended CC and Articus, and that the enforcement of Section 8.4.2 against my snow fence was arbitrary, capricious, and unreasonable. We also asked for declaratory relief, a preliminary injunction stopping the fines and attorney's fees. The HOA's response came 6 weeks later, filed by David Carlson. It was a motion to dismiss, arguing that the court lacked jurisdiction because I had not exhausted all administrative remedies within the HOA's internal process. Carlson also argued that the notice question was moot, because I had constructive notice of the amended CC and Articus based on their filing with the county. Rebecca filed a response brief dismantling both arguments. The internal remedies argument failed because I had pursued the appeal and the board had rejected it. As for constructive notice, Minnesota law was clear that filing with the county did not substitute for actual notice to homeowners. The statute existed precisely to prevent HOAs from making stealth changes to governing documents without informing residents. The judge, a no-nonsense woman named Margaret Torres, held a hearing on the motion to dismiss in early June. By this point, snow was a distant memory, and my fence had been taken down and stored in my garage for the summer. But the principle remained, and the fines were still accruing in the HOA's records, now totaling over $8,000. Judge Torres heard arguments from both sides and took the matter under advisement. 3 weeks later, she issued a written order denying the motion to dismiss. Her reasoning was clear and direct. The plaintiff had exhausted administrative remedies. The notice issue presented a genuine question of material fact that could not be resolved on a motion to dismiss, and the case would proceed to discovery and trial. That is when things started to get interesting. During the discovery process, Rebecca subpoenaed the HOA's records, including all emails, meeting minutes, and documents related to the amended CC and Articus. What she found was alarming. Patricia Hendricks had never actually sent the notification email to homeowners. There was no record of it in the HOA's email system. Moreover, the board meeting at which the amendments were supposedly approved had been improperly noticed. Minnesota law required at least 10 days' notice for board meetings where substantive actions would be taken, but Patricia had only sent notice 7 days before the meeting. 2 board members, Tom and Karen, had not even been present at that meeting. Only Patricia, Sandra, and Jeff had voted, and you needed a quorum of 4 board members to take official action. In other words, the entire amendment process had been legally defective from start to finish. The amended CC and Articles were invalid, and the citation against me was based on a rule that had never been properly enacted. Rebecca filed a motion for summary judgment, presenting all of this evidence and arguing that there were no genuine issues of material fact. The HOA's amendments were void, the citation was invalid, and I was entitled to judgment as a matter of law. David Carlson's response was surprisingly weak. He did not really dispute the facts Rebecca had uncovered. Instead, he argued that the procedural defects were minor technical violations that did not invalidate the board's action. He also tried to shift focus to the supposed problems my snow fence created, attaching affidavits from Patricia and Sandra claiming that the fence was ugly and damaged property values. Judge Torres scheduled another hearing for August 10th. This time, both Rebecca and I felt cautiously optimistic. The evidence was overwhelmingly in our favor, and the HOA's legal position seemed to be crumbling. The courtroom was nearly empty on the morning of the hearing, just Rebecca and me on one side, David Carlson and Patricia Hendricks on the other. Judge Torres entered and we all rose, then sat as she shuffled through papers on her bench. "I have reviewed the briefs and the evidence submitted by both parties," she began. "This is a fairly straightforward case, despite the parties' attempts to complicate it. The HOA failed to follow basic statutory requirements for amending its governing documents. There was no proper notice, no proper quorum, and no proper vote. The amended CC and Articles are therefore void." David Carlson stood up. "Your Honor, if I may, the HOA believes these procedural issues can be cured by ratifying the amendments now, with proper notice. Mr. Carlson, you cannot ratify something retroactively to validate enforcement actions that have already been taken. Mr. Zimmerman installed his snow fence before the amendments were enacted, or attempted to be enacted. He was cited under a rule that did not legally exist. That citation is void, as are the fines that have accumulated. I am granting the plaintiff's motion for summary judgment." I felt a wave of relief wash over me. Judge Torres continued, "Furthermore, I am awarding attorney's fees to the plaintiff under Minnesota Statute 515B.3.123, which allows for fee shifting when an HOA has acted in bad faith or unreasonably. The record here shows a pattern of procedural shortcuts and a concerning lack of regard for homeowners' rights. The plaintiff's attorney should submit a fee petition within 30 days. Patricia looked like she had been slapped. David Carlson was scribbling notes furiously. Rebecca squeezed my hand under the table, but Judge Torres was not done. "I also want to note for the record that this case represents a troubling abuse of HOA authority. Homeowner associations serve an important function, but they are not above the law. Board members who fail to follow statutory requirements expose their associations to liability and undermine the trust of the communities they serve. I hope the Meadowbrook Estates Board will take this lesson to heart." The hearing ended, and Rebecca and I walked out of the courthouse into the bright August sunshine. I felt vindicated, exhausted, and more than a little angry that it had taken 5 months and thousands of dollars to reach this point. "That was a strong ruling," Rebecca said. "Judge Torres clearly saw through their nonsense. Now we just need to calculate my fees and get them paid. I am estimating around $7,500 total, given the hours I put in and the complexity of the case." "Will the HOA actually pay it?" "They will have to. It is a court order. If they do not, we can execute on the judgment." Over the next few weeks, things settled down. Rebecca submitted her fee petition, and Judge Torres approved it in full. The HOA paid the judgment, along with voiding all the fines they had assessed against me. Patricia Hendricks resigned as HOA president in early September, citing personal reasons. Tom Sheffield took over as interim president and immediately began working to repair the association's reputation and processes. I thought that was the end of it. I was wrong. In late October, I received a call from Rebecca. "William, you are not going to believe this. The HOA just filed an appeal of Judge Torres's decision." "What? Why would they do that? They lost. It is over." Apparently, Patricia convinced the board to appeal before she resigned, and the motion was already in process. David Carlson filed the notice of appeal with the Minnesota Court of Appeals. They are challenging the summary judgment and the fee award. I felt my stomach drop. Can they do that? Do not I have to pay more legal fees to defend the appeal? Yes and yes. This is frustrating, William, but appeals are expensive and time-consuming. Most of them fail, especially when the trial court's decision is as well-reasoned as Judge Torres's was. But the HOA clearly wants to keep fighting, probably hoping you will give up or settle. I am not settling. They were wrong, and Judge Torres said so. If they want to waste more money on an appeal, that is their problem. Actually, it might become your problem too. If we lose the appeal, you could be on the hook for the HOA's appellate costs. It is a risk. I thought about it for a long moment. Rebecca, what are the chances we lose this appeal? Honestly, very low, maybe 10%. The Court of Appeals gives a lot of deference to trial court judges on factual findings, and Judge Torres made clear factual findings that the HOA violated the statute. The legal issues are not particularly close either, but there is always some risk when you go to an appellate court. Then we fight. File whatever response we need to file. The appellate process was even more tedious than the trial court proceedings. Both sides filed lengthy briefs arguing about procedural minutiae and statutory interpretation. Rebecca explained that appellate judges did not hear live testimony or consider new evidence. They only reviewed the record from the trial court and decided whether Judge Torres had made any legal errors. The oral arguments were scheduled for March 3rd, almost exactly 1 year after the original board meeting where my appeal had been denied. The Court of Appeals sat in St. Paul. So Rebecca, and I made the drive up from Rochester on a gray, cold morning that reminded me of the winter storms that had started this whole mess. The courtroom was more formal than Judge Torres's, with ornate wood paneling and a high ceiling. 3 judges sat at the bench: Chief Judge Michael Brennan, Judge Lisa Howard, and Judge Robert Chen. David Carlson argued first for the HOA, essentially rehashing the same points he had made in his briefs. He claimed that Judge Torres had been too strict in interpreting the notice requirements, that the procedural defects were harmless errors, and that the fee award was excessive. When it was Rebecca's turn, she methodically dismantled each of his arguments. She pointed out that the Minnesota legislature had written the notice statute in clear, mandatory language. There was no provision for harmless error. Either the HOA provided proper notice or it did not. It did not. As for the fee award, Judge Torres had carefully calculated it based on reasonable hourly rates and actual hours worked. There was no basis for second-guessing her discretion. Judge Howard asked several pointed questions about whether the HOA could have ratified the amendments after the fact, and Rebecca explained that ratification could not validate enforcement actions that had already been taken. The citation and fines were based on a rule that did not exist at the time, and no amount of after-the-fact paperwork could change that. The oral arguments lasted about 45 minutes total, and then the judges thanked the attorneys and took the matter under submission. Rebecca explained that it could take anywhere from 6 weeks to 6 months for the Court of Appeals to issue its decision. The opinion came down on May 18th, and it was even better than I had hoped. The Court of Appeals affirmed Judge Torres's decision in its entirety, finding no reversible error in her analysis or conclusions. But the court went further. In a scathing section of the opinion, the judges noted that the appeal itself appeared to lack substantial merit and seemed to be a continuation of the HOA's unreasonable behavior. Under Minnesota Rule of Civil Appellate Procedure 139, the Court of Appeals had the authority to award sanctions for frivolous appeals. The court found that the HOA's appeal met the criteria for sanctions because it was not warranted by existing law and appeared to be filed primarily to harass the plaintiff and increase his costs. The court ordered the HOA to pay an additional $5,000 to cover my attorney's fees for defending the appeal, and it issued a reprimand to David Carlson for filing a meritless appeal without conducting adequate legal research. When Rebecca called to tell me the news, I could hear the satisfaction in her voice. "William, this is a total victory. Not only did we win on the merits, but the Court of Appeals essentially punished the HOA for wasting everyone's time. This is going to send a strong message to other HOAs in Minnesota about following the law and not abusing the legal process." I felt a profound sense of relief and vindication. It had been a long, exhausting fight, but we had won decisively. More importantly, we had established a precedent that might help other homeowners facing similar abuses. The fallout from the Court of Appeals decision was immediate and significant. Tom Sheffield called me the day after the opinion was published to apologize on behalf of the board. "William, I am so sorry you had to go through all of this. The new board has reviewed everything that happened, and we are taking steps to make sure nothing like this happens again. We are updating our procedures, providing proper training to board members, and we have parted ways with David Carlson. His advice throughout this case was terrible. I appreciate that, Tom. I never wanted to be at war with the HOA. I just wanted to use a snow fence to keep my driveway clear." "I know, and you were absolutely right. For what it is worth, several other homeowners have told me they want to install snow fences this coming winter, and the board is going to approve all of those requests. We learned our lesson." David Carlson faced professional consequences as well. The reprimand from the Court of Appeals became part of his public record, and several homeowners associations that had used his firm switched to other attorneys. I heard through the grapevine that his partnership was dissolved later that year, though I never confirmed the details. As for Patricia Hendricks, she kept a low profile after resigning as HOA president. I would occasionally see her at the grocery store or around the neighborhood, but we never spoke. I held no particular animosity toward her, but I also had no interest in rekindling any kind of relationship. She had made her choices, and she had to live with the consequences. The following winter, I installed my snow fence again in November, this time with full approval from the HOA board. When the first major storm hit in early December, I stood in my driveway watching the snow deposit harmlessly in the field beyond my property, and I felt a quiet satisfaction. It had taken nearly 2 years, thousands of dollars in legal fees, and an appeal to the state's second highest court. But I had vindicated my right to use a simple, practical tool to maintain my property. Several neighbors stopped by over the course of that winter to ask about my fence and whether they could install their own. I shared Rebecca's contact information with a few of them, though most found the new board to be much more cooperative than Patricia's regime had been. Tom Sheffield proved to be a fair and reasonable president, focused on maintaining the community without micromanaging people's lives. In March, almost 2 years to the day after that fateful board meeting, I received a check from the Meadowbrook Estates HOA for $15,000, covering all of the attorney's fees and sanctions awarded by the courts. I deposited it immediately and wrote a check to Rebecca for her remaining unpaid balance. She had worked on contingency for part of the case, gambling that we would recover fees if we won, and her gamble had paid off. "You know," Rebecca told me over coffee a few weeks later, "your case has become something of a legend in HOA law circles. I have had 3 other attorneys contact me asking for copies of the briefs and opinions. It is a textbook example of how to fight back against an overreaching HOA. I am glad something good came out of all this. I just wish it had not been necessary in the first place." Unfortunately, William, HOA disputes are becoming more and more common. As associations gain power and control over people's lives, there are always going to be board members who abuse that power. Cases like yours help establish limits and remind everyone that HOAs are subject to the law just like everyone else. I thought about that conversation a lot over the following months. The American dream of homeownership increasingly came with strings attached in the form of HOA rules and restrictions. Sometimes those rules made sense and genuinely enhanced the community. Other times, they were arbitrary exercises of power by people who enjoyed controlling their neighbors. My case had drawn a clear line. HOAs had to follow their own rules and the laws that governed them. They could not simply make up rules on the fly and enforce them retroactively. They could not skip procedural requirements and then claim harmless error when caught. And when they overstepped, homeowners had the right to fight back through the courts, with the possibility of recovering attorneys' fees when they prevailed. The snow fence itself, the humble orange plastic barrier that had started this whole saga, continued to serve its purpose every winter. It was a reminder that sometimes the simplest solutions are the best, and that standing up for what is right, even when it is difficult and expensive, can make a difference not just for yourself, but for others facing similar challenges. Tom Sheffield served as HOA president for 2 more years before stepping down, replaced by a retired engineer named Frank Morrison, who brought the same practical, no-nonsense approach to the role. Under their leadership, Meadowbrook Estates became a genuinely pleasant place to live, with a board that focused on maintaining common areas and resolving disputes fairly rather than looking for reasons to fine homeowners. I stayed in my house, enjoying the changing seasons and the knowledge that I had fought a good fight and won. Buster grew older and grayer, spending his days lounging in the sunny spots in the backyard. My driveway remained clear every winter, thanks to my snow fence and the Court of Appeals decision that had affirmed my right to use it. Looking back, I sometimes wondered what would have happened if I had just removed the fence when Patricia first issued the citation. I would have saved myself time, stress, and a significant amount of money, even accounting for the fees I eventually recovered. My winters would have been harder, with more hours spent shoveling and more days when I could not easily get my car out of the driveway. But I also would have sent a message that bullying works, that HOA boards can ignore the law as long as they are willing to threaten fines and legal action. Other homeowners would have continued to suffer under Patricia's regime, afraid to challenge her authority or assert their rights. By fighting back, I had changed that dynamic. The Court of Appeals opinion was now part of Minnesota case law, available to any homeowner facing similar circumstances. Attorneys could cite it, judges could rely on it, and HOA boards had to take it into account when making decisions. That felt like something worth fighting for, worth the sleepless nights and the mounting legal bills and the stress of litigation. It was not lost on me that I had certain advantages that made this fight possible. I had a stable income that allowed me to afford a lawyer. I had the time and energy to pursue litigation over the course of 2 years. I had found an excellent attorney in Rebecca who believed in the case and was willing to work with me on fees. Many homeowners facing similar situations would not have those advantages, and they would be forced to either comply with unjust rules or suffer mounting fines they could not afford to pay. That is why precedents like mine mattered. They gave other homeowners and their attorneys ammunition to fight back, to push for settlements or dismissals based on established law. They created accountability for HOA boards and their attorneys, who now knew they could face sanctions if they pursued legally baseless enforcement actions. As spring turned to summer and another year passed, life in Meadowbrook Estates settled into a comfortable rhythm. The HOA organized community events, maintained the common areas, and handled the routine business of running a residential association without drama or controversy. It was what an HOA was supposed to be: a useful administrative body that enhanced property values and quality of life without intruding unnecessarily into people's private affairs. I occasionally gave talks at homeowner rights organizations, sharing my story and encouraging others to stand up for themselves when faced with unreasonable HOA actions. Rebecca sometimes joined me for these presentations, explaining the legal principles involved and offering practical advice for homeowners considering litigation. The message was always the same: know your rights, document everything, and do not be afraid to fight back when the HOA overreaches. The law was on the side of homeowners who were treated unfairly, but you had to be willing to assert those rights through the proper channels. It was not easy and it was not always quick, but it was possible to win. My snow fence became something of a local landmark, a symbol of the importance of standing up to unjust authority. Neighbors would point it out to visitors, telling the story of how a simple orange plastic fence had sparked a 2-year legal battle that went all the way to the Court of Appeals. Some people thought I was crazy for fighting so hard over something so minor. Others saw me as a hero who had stood up to the HOA and won. I was neither crazy nor heroic. I was just a homeowner who wanted to use his property in a reasonable way and refused to be bullied by an overreaching HOA board. The fact that it took 2 years and multiple court proceedings to vindicate that simple principle said something troubling about the state of HOA governance in America. But it also showed that the legal system, for all its flaws and expenses, could still deliver justice when properly invoked. The fines that the HOA had tried to impose, which would have totaled well over $10,000 if I had not fought them, were erased completely. The attorney's fees I had paid were fully recovered, plus the sanctions awarded by the Court of Appeals. The amended CC and Articles that Patricia had tried to impose without proper notice were declared void, and the HOA had to go back and properly notice any future amendments it wanted to make. In the end, I came out ahead financially, though not by much once I accounted for the time and stress involved. But that was never really the point. The point was establishing that HOAs could not run roughshod over homeowners' rights, that procedural requirements existed for a reason, and that the courts would enforce those requirements even when it meant overturning HOA decisions and sanctioning their attorneys. As I write this, sitting in my home office looking out at the driveway where my snow fence stood during those difficult winters, I feel a deep sense of satisfaction. The fight was worth it. The precedent was worth it. The message it sent to HOAs across Minnesota was worth it. And every winter when I install my snow fence and watch it efficiently manage the snowdrifts that would otherwise make my property unusable, I am reminded that sometimes the smallest battles are worth fighting because they represent something much larger. The right to use your property freely, the right to be treated fairly by those in authority, and the right to hold them accountable when they fail to live up to their legal obligations. Patricia Hendricks never apologized, and I never expected her to. People like her rarely admit when they are wrong or acknowledge the harm they have caused, but the legal system did not require an apology. It required accountability, and that is exactly what Judge Torres and the Court of Appeals delivered. The decisions in my case stood as permanent reminders that HOA authority had limits, and that homeowners who were willing to fight could enforce those limits. The story of my snow fence spread beyond Minnesota, picked up by homeowner advocacy groups and legal journals focused on property law. It became a case study in law school courses on HOA governance and appellate practice. Attorneys cited it in briefs, and judges referenced it in opinions. What had started as a local dispute over winter maintenance had become part of the legal landscape, available to guide future cases and inform future decisions. And that, ultimately, was the greatest victory. Not the money recovered, not the fines avoided, not even the satisfaction of winning, but the knowledge that my case had contributed something lasting to the body of law protecting homeowners from overreaching HOAs. It was a small legacy, perhaps, but it was mine, and it made every moment of the long, difficult fight worthwhile. The snow fence still stands every winter, orange and practical and utterly unglamorous. But to me, it represents something beautiful. The principle that ordinary people can challenge unjust authority and win. That the law, properly invoked, can protect the rights of individuals against the arbitrary exercise of power. And that sometimes the most important battles are fought not over grand principles, but over simple, practical necessities like keeping your driveway clear in a Minnesota winter.